Folks, we're back. This is Steve Sanson and Frank Friends with Veterans in Politics. Today, our guest is going to be Alex Falconi. He's the founder of Our Nevada Judges. But before we get to Mr. Falconi, Frank, any rants?
Oh, yeah. A few of them. Stop bullshitting. Learn your local politics. Stay away from bad CCW instructors. That'd be a good one. And legalize mutual combat. I'm just saying. Get rid of a lot of assault time on police officers charged with a fray. And if two dudes or girls want to run their mouth, they can throw hands.
You know, I got one. I think they should legalize marijuana federally because in Washington, D.C., they got there's 3 or 4 dispensaries over there.
Well, the problem with the legalization isn't even that. Why the hell is it a Schedule I narcotic? Why?
I want to know why Congress and senators get to smoke weed, but they don't want to make it federally legal in this country.
You might want to ask our VP that, because she used to do that a lot while listening to Tupac and Biggie in college.
Oh,
yeah? At a time that they weren't producing CDs or tapes. Yeah. But she smoked weed to them.
How'd you know?
While prosecuting young black men for the same crime.
How you know that?
I heard they found some drugs in the White House.
Oh, coke.
Yeah, it wasn't weed, so we don't got to really worry about it. Because, coke is a lower scheduled narcotic than marijuana. Mm-hmm. Think about that, people.
I actually didn't know that.
Yeah. Schedule I narcotic. Same thing as PCP and acid.
Okay. And you know this how?
It's on the books. Just go look it up. It's been that way for a long time.
All right. Well, Mr. Falconi, tell us a little about yourself. Oh, first of all, thanks for coming on the show.
Thank you for having me. I am the administrator of the Our Nevada Judges organization. I decided to really create the Our Nevada Judges organization when I was representing myself in court, child custody case in Washoe County. And I just started to file appeals and started winning appeals. And after winning 3 or 4 appeals, I wondered, is there some system somewhere that tracks how often judges make mistakes? So I started looking around. I didn't find one. That's all it was in the very beginning. It was just a website. They compiled all of the appellate dispositions of judges, whether they were upheld or overturned. And that's all I ever thought it would be. Most people don't know that the camera stuff and what Our Nevada Judges became today was never really just a big idea that I had. It was 1,000 small ideas and decisions that eventually led to today. So in 2019, I started deploying cameras to the courtroom. And I noticed that the public learned a lot more from the camera than they did from the statistics. So ever since that day, I sort of decided maybe this should be more of a news and media thing and less of just a hobby website. And that's pretty much the Our Nevada Judges people know now, which is that we send cameras to courtrooms throughout the state. Pretty much, I'm not going to say every county, but more than half. We go to the justice courts, the municipal courts. We've recorded the Commission on Judicial Discipline. We've recorded the parole and probation. They're letting us set up a camera in JAMS ADR. And that's kind of the nutshell version of what I do is we try and show the public and attorneys watch and judges too, but most of our viewers are the public, how the courts are operating. Rather than tell them what the courts are doing, we show them through the lens of a high definition camera.
You got a YouTube channel?
We have a YouTube channel. We have a Facebook. We have a Twitter. We have the actual website itself. All of these additional things that we have point to the website. For me, the organization is the website. Mm-hmm. And most of the people do find out about us through the YouTube and the Facebook. And those are very easy to find. Facebook is facebook.com/Our Nevada Judges. And it's the same for YouTube and Twitter, twitter.com/Our Nevada Judges.
How did you get from family to parole and probation? That's a jump.
So a lot of people think that the purpose of Our Nevada Judges is to confront family court. But believe it or not, very little of our coverage is family court. Mm-hmm. And when I started to deploy cameras to the courtroom, I never had a plan to deploy cameras to family court. I just assumed that it was just something that wouldn't be allowed. Mm-hmm. The reason that so just to answer your question, what's left if you're not in family court? It's criminal cases, civil cases, and criminal cases, they lead
probate.
They end up, all that stuff. And when somebody gets convicted, they end up in parole. So I asked them to put a camera in there, etc. What caused me to actually decide to pull the trigger and try to put a camera into family court was the Judge Judy interviews. Mm-hmm. I mean, I was always sort of 50-50 on it. But
Right.
her interviews pushed me over the edge.
Mhm.
She has 2 interviews. Everybody knows about the Norm Macdonald interview. That's the big one.
Mhm.
The other one I found more insightful, and it was on 60 Minutes or something like that. It's a lot harder to find.
Mhm.
But when I heard what she said, it made me think it was worth fighting for. And I looked into some of the history of it. And I don't know if people know this, but she's a TV judge now, but she used to be a family court judge. A lot
You
of
know
people
what she
don't
says
know
about
that.
family court judges?
It's what she says on Norm Macdonald. It's in the Norm Macdonald.
What does she say about family
She
court
says that family court is these are her words. So if anyone gets pissed off at me, it's her. I'm going to quote mostly verbatim. Quote, the dumping grounds for morons and political hacks, unquote. And the reason she says that is because she says that it seems to her that family court, because of its confidentiality and secrecy and all that, it draws certain types, low quality attorneys and judges these are her words again. Don't get mad at me. I'm just a messenger. Like a moth to flame, it draws those types of practitioners to family court.
They say that it's attorneys that can't make it in private practice.
And that's
court.
the gist of her interview. And in her words, she says, well, you can't put these people anywhere else because press goes in there. We have to hide where we're putting these types of people. She says it right there to millions of people. She says it. Mm-hmm. And then in her other video, she explains, she takes less of a dramatic approach, but she says that closed hearings foster bad judging and bad lawyering. That's the summary of what she says at the end. So when I saw those, I decided to try it. And of course, I encountered a tremendous amount of resistance. But with some effort, I was able to get cameras into those courtrooms for all of the attention that people have on our lawsuit against the district. I do want to call out judges who have allowed us, to put cameras into their courtrooms. We have Judge Almasi, we have Judge Throne, we have Judge Schreinerdt up in Reno, we have Judge Cynthia Liu also up in Reno, Egan Walker, who did a little bit of both. And now he's not a family court judge anymore, but he was. Michelle Mercer allowed a camera in. Perry allowed a camera into an adoption. So, I mean,
Perry allowed cameras during the adoption?
The only reason...
A case that was already done and already dictated and ready to roll.
The only reason, because the statute doesn't allow cameras into adoption, is because the parents consented in writing and provided consents to the court. Otherwise, she wouldn't have allowed it, which would have been fair. I hope I didn't forget anyone. David Gibson was one of the big ones. David Gibson Jr. allowed a camera into an NRS 432 BCPS case, and they lost their minds. They absolutely lost their minds when they allowed that.
But don't they know the courtroom is already recorded? And you could go get the audio and the video for the court hearing.
I'm really in cases they don't seal them.
No. Well, you know what though?
Well, even the sealed case, you couldn't get in there in the first place.
Well, here's the thing about
they like to do that to you.
Well, here's the thing about sealed cases though. Even if a case is sealed, the parents still have access to the JAVs. And the people who release the JAVs, it's usually one of the parents.
Not only the parents, the judges have access to it. The JDA have access to it. The law clerk has access to it. The marshals could get access to it. Right. Any judge could get access to it.
Right. I don't know. You understand what's going on. So I do want to talk about the issue of JAVs and why they talk about that. I think that the effort to impede the deployment of a high definition camera into a courtroom has to do with less viewers, less people paying attention. And I think that judges and attorneys are cognizant of the fact that the higher the quality of the presentation, the more people are going to see it. So when I hear things like, you don't need to put a high definition camera in here, what I hear is, we don't mind if 20 people watch it, we just don't want 2,000 people to watch it. And so they're trying to control the amount of people that see what they're doing. That's what's going on. Mm-hmm. So
do you think that when attorneys and judges don't want cameras in their courtroom or don't want a audience sitting in the courtroom, they're really trying to protect themselves from any wrongdoing that might occur during the course of the case?
In my very honest opinion, the answer is yes, because if you want to protect kids and families, there are things you can narrowly tailor protections to protect kids and families. Mm-hmm. So, you could say we're going to protect kids and families with this specific hearing for this specific amount of time for this specific issue. Mm-hmm. The idea that you're just going to seal an entire file or that you're just going to close an entire hearing, to me, that's overly broad. And if a judge wants to protect kids and families without protecting themselves and their lawyer friends, then they're going to find a way to allow the press to cover as much of the case as possible, with the exception of those portions that need to protect. I mean, it's not unreasonable for the public and society to expect to have transparency in a general sense and confidentiality where needed, narrowly tailored. That's not an unreasonable request.
So you're saying, like, if there's an abuse section in the case, that gets sealed. Nobody gets to be in there to hear the abuse of the child.
That's what
everything else litigated is visible.
That's what the rest of the court system does. The rest of the court system applies by what they call them the SRCR, Supreme Court Rules of Sealing and Redaction, and they have these criteria. And then there's the First Amendment of the Constitution, which has its own criteria. Nobody else in the court system says, kids, close it. Nobody else does that. Just family court. And you know what's weird is we have cases in criminal court that have kids.
But doesn't the Nevada revised statute says you cannot seal the entire court case? But they do it. And when you seal the entire court cases, litigants from, let's say, out of state nobody actually could access the court, especially litigants from out of state. And they got to drive in from out of state to come here to actually get a copy of their case. And they couldn't even get it online because some moron sealed the entire court case.
So yes, it's not an NRS, it's a SRCR. I think it's 3. So I don't know how many times my lawyers cited it. Luke Busby, an amazing guy up in Reno. Yes, it's forbidden, but the problem is.
Then why did they get away with it?
Well, what I'm going to tell you is in that Supreme Court sealing and redactions rules, there's another provision that limits the scope, and in that scope, they have a bunch of chapters that they've defined. And it doesn't say that the chapters are exempt from the SRCR, but some attorneys and judges read it that way. What it says is that when there's a conflict with the statute prevails. But some attorneys and judges go, oh, look, this is listed here, so this whole thing doesn't apply, so we can seal the whole thing. I agree with you on this in principle. But I think it's not going to really be resolved until the Supreme Court rules on the lawsuits that we filed.
Because that seals the entire case, and no litigants can even have access to your case. And these out-of-state litigants are disenfranchised by it.
They're very disenfranchised. I mean, you can't see what's going on. You're dumb, deaf, and blind as to what's going on.
And the attorneys are getting the upper hand, right?
Well, if you have a system where you say you have a sealed case and attorneys can go into it and the public can't, which includes
and a pro se litigant can,
then there's obviously a disadvantage there. I mean, that's obviously a problem.
So they're violating the 14th Amendment.
That would be another
fair judiciary.
That would be another. A lot of people have talked to me about that, and all I can tell them is that we've already filed suit targeting the statutes and rules with the principles that we've brought. If other people want to use the 14th Amendment, they can. But I'm not sure that it's going to matter because I think we're going to get a ruling pretty soon anyway. And I'm not going to say I'm 100% confident, but I'm going to say that I feel like most likely the First Amendment will prevail. And that all of this stuff's going to end up getting dealt with soon anyway.
And how about closed courtrooms? I remember the case is not sealed, and I have my court observers in there, and the attorney doesn't like the fact that court observers are in there.
We get kicked out.
And ask for a closed hearing. But to get a closed hearing, according to the way the NRS reads, to get a closed hearing, they have to file a motion ahead of time. And these people are just saying it right then and there, and the judge is honoring it.
As soon as they see you.
Because the judge is a moron.
So they're using a different, I think that
Judge, you're a moron if you honor that.
Yeah.
I think that it would be best, I know that that's what they should be doing.
And then what happens is, Alex, I don't say nothing. I used to argue it.
Yeah.
I used to argue it. I've been in front of Tootin arguing it, but I take away time from the court when I do that. But I just go downstairs and order the same hearing that they freaking closed on me. And now instead of 5 of us watching it, now 5,000 of us watching it, because now I'm taking it and I'm putting it on my YouTube channel. Mm-hmm. You attorneys and judges are just stupid.
Don't they call that the Barbara Streisand effect or something like that?
Is that what they call it?
I think they call it when you try to hide something, it just ends up making more people look.
Yeah, you get making more people watch it.
Yeah. It's the Barbara Streisand effect.
Because all I was going to do in some of these cases, not Frank, because Frank's been with me in a lot of these cases. Yeah. We're just going to go in, sit, and walk out. Yeah. But when they go, okay, now we want to look around. Now we want to close hearing. And the judge is like, yeah, close hearing. I don't like those motherfuckers either. And they close the hearing. Yeah. And I'm like, okay, bye-bye. And I go downstairs and I order the video And then I get the video, and then that same closed hearing and I'm watching this video like, what in the world did they close it for? And I'm watching it, I'm like, man, they're so damn stupid.
Steve, you know why they closed it.
Yeah, because we're in there.
Well, because the greatest disinfectant is sunlight. He wants to shed light on it. You've been trying to shed light on it. I've gone with you. Mm-hmm. As soon as you get in there and you start seeing what's happening in these courtrooms, and guys, if you're going to court, learn the laws, learn the things you're going to be participating in, like, burglary, defamation of character, learn what it is, and use the exact codes against the judges and attorneys when you're fighting them. They can't stand it, and they can either do one of two things. They can either follow the law and do it, or they can dictate from the bench. And once they start litigating and dictating from the bench, you got them.
Please continue.
I don't remember where we left off. Closed hearings?
Yeah,
mm-hmm.
Closed hearings.
Yeah, I do think that. I mean, for me, just from an operational standpoint, for me, when I'm covering a case, it's frustrating when a hearing is close to a sponte. Judge Breslow up in Reno did that recently. And the basis, I guess, is valid, but I would at least like to know it in advance. So if there was some kind of motion filed in advance saying they want to close a hearing for a particular reason, it would give me a heads up. I know that from the perspective of the media, I appreciate having that kind of notice. I wish that they would do that. But I do understand what you're saying, that in practice, they don't do that. They just say, hey, I demand it's closed, close it, and that's it. It's over. And they use a different statute to do that. You're talking about the divorce statute. Yeah.
So, Frank?
Well, like I said, the fastest way to get through this stuff, Steve, is have the exposure that he's trying to give to it. And if you guys are involved in cases, or if you ever even think you're going to have kids, get involved locally, do something, follow his YouTube channel, get in there, get involved, and bring light to what these judges and attorneys are doing. I mean, my court case took 4 years, and if anybody had ever watched the court case, they would have known that best interest of the child is to be with me. It took 4 years, and it finally happened. But like he said, a lot of judges get it wrong. I mean, you said your case originally, you had visitation, and now you have complete parental rights.
I started out with supervised visitation, and then at the very end, they terminated my ex's parental rights.
Yeah. So, I mean, these judges are getting it wrong all the time.
Well, the problem is that the basis of the termination of parental rights was for abandonment. Mm-hmm. So that was not, she didn't oppose it.
Abandonment is 6 months.
Yeah, she's been gone ever since. She's just gone.
Right. So if these judges don't even follow their own rules, because abandonment is 6 months, right?
There's a statute that says there's a presumption of abandonment, if that's what you're talking about. Yeah, and that's what we used. Yeah. Okay. So if you're not involved in the child for 6 months with zero contact, then it automatically goes to the other parent. Well, they say there's a presumption. You know how that goes. Sometimes the judge might rebut it or something like that. But in our case, in my case, it wasn't rebutted, and they entered the TPR. Yeah. Okay. So how do you see the family court from when you first started going into these courtrooms? Well, in 2019 till now. Has anything changed? I see that a lot of things have gotten better, but some things have gotten worse. Mm-hmm. So I see that the joint physical custody is being dispensed more. When I observe, I see judges are not coercing settlement as often as they used to be. Mm-hmm. Child support. It seems to me like judges are listening to people more than they used to. But the problems that I see have to do with attorney fees in Clark County. Mm-hmm. I think that they're issuing attorney fees way too often. Mm-hmm. And especially when somebody goes in there who's too poor to afford an attorney. And I get this vibe sometimes that the judge feels bad about the person who was wealthy enough to afford an attorney. And I think that they really should rethink that new statute that they created that gives the judges the discretion to award attorney fees in custody cases. Because that didn't exist when I was litigating my case. Mm-hmm. To get attorney fees in my case, it was 18.010 sub 2B, which said that you had to not only lose, but they had to show that you brought, whatever it is that you brought to the court unreasonably. And I faced 7 attorney fee motions, and I fended off 6 of them because of that statute and its language. One of them I won an appeal on. And I think that the new statute that the legislature created is a disgrace, and it's causing these attorney fee awards to be awarded more often than they should be. And I know that that is a source of outrage and anguish for parents. So that's the one thing that I think is a big problem. But everything else seems to be moving in the right direction. I'm not sure if you like that opinion, but based on what my personal experiences back in 2008, I see an improvement over time. And of course, this is a generalization. Different situations with different judges. Judge Arthur Ritchie allowed me to sit in his courtroom last week, and I was pretty amazed by how he treated everybody. I thought to myself, if I was treated that way, I may have never even created our Nevada judges. So it really depends on the judge, but in the general sense, I see things moving in the right direction.
I see him as biased towards one particular attorney.
That's I left that out, but that's why I said generally.
It's like he's scared of this attorney.
When you involve certain attorneys in certain cases, I do think that some judges, especially in family court, give a lot of weight to a particular attorney. This is not a conspiracy. This was talked about by the Legal Aid Coalition when they filed their brief. I don't know if you read it. So in my lawsuit, the Legal Aid Center, Southern Nevada, Northern Nevada Legal Aid, Nevada Legal Services, and the Rurals, they all filed a brief. In writing, they said that there's a clubby atmosphere in family court and that closing the courtroom doors are exacerbating the problem. So I just wanted to be clear, this is not a conspiracy when all 4 legal aid centers put it in writing in a brief before the Supreme Court. And I think that is what you're talking about.
That's a problem.
That's a very real problem. It's not a problem that random parents are saying. It's a problem that even legal aid is saying exists. Deborah Bookout signed that brief. She's an attorney.
Didn't the chief executive for the courthouse decide to close all custody cases?
So that was, you're talking about the Wednesday crisis? Yeah, he did. So is
that what you call it, the Wednesday crisis?
It's a crisis. The thing is, people who don't represent themselves, it's hard for them to understand why it's a problem. When you're representing yourself against an attorney especially, there's a tremendous amount of anguish and paranoia and fear and anxiety. And one of the ways that I used to solve that, and most other litigants, Karen McAlee, who's the administrator of Clark County Family Court Support Group, understands this, is you check your docket to know if something is in there. Sometimes you're waiting for a ruling. It just calms you down. Losing access to your docket, and this is just the people. We're not even talking about the attorneys who can't even get in there now. People have been leaking me emails left and right from attorneys who are freaking out. Yes, the Wednesday decision, let's talk about that a little bit more. So the Wednesday decision, really, the clerk was just abiding by the rules that were implemented. The rules say they're supposed to be converted. So what he did was he took all of the cases that were custody, so the C cases, and he converted them all to P cases. All of them. P's for paternity. Okay. So once he converted them to P cases, the statute triggered and superseded everything. That's what happened. So the clerk wasn't really doing anything wrong. He was just following orders. And those orders were implemented by the judiciary. So the 8th Judicial District Court promulgated those rules. We already sued them on these rules. It just took, I guess, a long time for him to actually implement the mechanism. A long time. That's what happened. I mean, he didn't really do anything wrong. He did what he was ordered to do by the same judges who promulgated those rules.
But he took his own sweet time about doing it.
I don't know for sure if it was his own sweet time or if it was because of the electronic system that they use having issues. But I will say this, it took so long that I assumed they were doing it on purpose. I assumed they were just waiting for the ruling. That was just my assumption. And I guess I was wrong, and it just took a really long time, and it finally just hit. So yeah, it's...
Do you think that paternity cases, when parents are losing their rights to their children, or relocation, do you think that one judge should make that decision, or do you think there should be a panel of judges?
I love that you brought this question up. You're talking about whether there should be a panel or whether there should be a jury. I understand that this is coming from the perspective that judges cannot be trusted, so we want to bring in regular people or outsiders to make these decisions. I understand where this is coming from. I really don't think that'll solve the problem, first of all, because Texas already does this. Texas has jury trials in family court already. Second of all, the problem is even worse because there's so many pro se litigants in family court. 65%. And now they're going to have to figure out how to do jury selection and prepare jury questions. It's gonna cause issues. Then there's the expense. But then there's the other problem is, how logistically do you involve a jury when most of, I think, the discretionary problems people have to do with temporary orders? And judges in ordinary cases don't involve juries with temporary orders anyway.
So then you're leaning towards a tribunal.
No, I mean,
instead of juries.
So I think that if you didn't do a jury and you had some kind of sitting tribunal, it would probably be helpful, and it would probably give people some semblance of confidence that there were outsiders. But I think most importantly is to just show people what's going on in there so that the public has more influence over the judiciary. Because I really see this more as a problem of influence. I don't see this as there's a lot of small problems, but I think that when you have public access and transparency and camera access, and the judges are aware that the public is watching, there is a much more influence taken away from the attorneys and given to families and the public. And I think that might actually get a lot closer to solving the problem than evolving all of these extra mechanisms. I really do.
Tell you how to solve that problem he's talking about. I can tell you how to do that.
Yeah, he's finishing up.
Yeah. Well, so I think the first step should be to make family court as transparent as it possibly can be, so people can see what's going on, so the public can have influence over this process because it's their families. And then at that point, maybe consider some of the other proposals. But for me, it's family court is such a convoluted thing that just logistically finding out when to involve all of these other people is going to be a problem in and of itself. In my own case, I only had 2 evidentiary hearings. So what are we going to do? How are we going to involve all of these people and all of these other steps? I mean, there were over 100 filings. I lost count of how many hearings there were. And Texas doesn't do it either. Texas has a jury, but they only put the jury in for the bench trial, for the jury trial, or if there's an evidentiary. They don't involve them throughout and the jurors are going to get ticked. We have to say that on camera. Jurors are going to be pissed off if you make them sit through family court cases. They just are. There's no way they're just not going to like it. So if there was a jury, it would be like maybe 2 or 4, so it's not so many.
Well, you got juries that don't like sitting in murder cases and rape cases and
it's really
class action cases.
Right. It's really a problem of influence. And I think solving the problem of influence is to get people to see what's going on in there, to readjust and recalibrate so that it's not just divorce lawyers who have influence over the family court. That's what I think. That should be the first step. And then we'll see what happens from there.
So a family court judge is a civil judge, correct?
Correct.
Why are they being allowed to conduct criminal court in their courtroom, especially ordering litigants to take drug tests when they don't have jurisdiction to do it?
So that's not something that I really have knowledge of. If you think that there should be some authority codified, that sounds to me like a reasonable thing. I can answer that. If you think that judges shouldn't be able to order drug tests unless there's a statute or rule.
According to the Nevada revised statute, only criminal judges could do that.
Yeah, if there's a violation of law there, somebody would probably have to take that up on appeal or by
But then they hold their children hostage and deem your urine dirty if you don't want to even do it.
Yeah, I mean,
and
you're talking
hold
policy
the children hostage, which is another violation of the NRS.
I mean, I think that basically at this point you're talking policy because on the one hand, the criminal side of it's going to say search and seizure warrants, et cetera, et cetera. But then the other side is going to say best interest factors. So where does the authority come from? I mean, that's something that the Supreme Court would have to answer or that the legislature would have to codify. But your concern is valid. I do get emails from some litigants who complain about them getting a dirty test that wasn't actually dirty and stuff like that. So people do talk about that.
I had one that was complaining about the patch program.
Yeah, the patch is popping dirty all the time.
Right.
And then there's another one that if a family court judge is a civil judge, why are they doing contempt of court hearings?
They actually can do that. So this is an interesting thing that I had to research when I was representing myself. I have to be careful because I don't want to wander into the realm of an attorney because I'm not an attorney. But what I will say is this. They do have a distinction between civil and criminal contempt, and they don't categorize it based on the type of hearing. They categorize it based on the type of punishment. So some people think that criminal judges can do criminal contempt and civil judges can do civil contempt. Based on my research and what I ended up citing in my case when I was representing myself, it's not like that. The manner in which the judge is trying to punish someone determines whether it's criminal or civil.
So you're saying that a civil judge could only fine someone for
they could still
lock you up.
The thing is that
but they're not criminal judges.
It doesn't. It actually now you're talking about another.
Now
case.
they're trying to take away your.
Now you're talking about
freedom.
Now you're talking about another debate, a separate debate, which this was back in several years back, where family court judges, I guess, were being categorized into a very narrow category, and the Supreme Court said they were based on a statute that lumped them into family court. And then later on, they challenged it, and the Supreme Court heard it again and changed their mind and said, based on the Constitution, that a district court judge has the powers of the district court judge as outlined in the Constitution, and they didn't limit their powers. I understand what you're saying. People don't want civil judges to be able to do certain things because, again, they don't trust them, but they can, in my opinion.
And also, aren't they biased because they're the ones that recommended contempt of court hearing? Now they're a biased judge. They recommend the contempt of court hearing, and they're the ones that's going to preside over the contempt of court hearing. I wonder how that's going to go.
Well, you're talking about something that's also been codified. Mm-hmm. So there's another statute that in ordinary situations, if a judge says he's going to hold you in contempt, not directly in front of them, that you can object and get a different judge. But there's exceptions listed in there, and one of the exceptions is family court. Mm-hmm. But so, I mean, you're talking policy again. So, I mean, that's really a question of the legislature changing the statutes and allowing you to kick a contempt judge off in the family court again. I mean, if they want to. They probably started out that way, and then they probably later created the exception because too many people were doing it because family court has a bunch of contempt stuff flying around. I don't know. I didn't look at the history of it. But yeah, that's been discussed by the legislature. There's a statute there that says you can do that. So it's not just you that notices that issue.
I'm glad.
Yeah.
So what else would you like to discuss that we haven't discussed already?
Well, I mean, I think, we kind of shot through everything.
Yeah.
I got some ideas.
Go ahead.
So you're talking about exposure to them and how corrupt family court is all the time. And how
all the time
family court.
I wouldn't say
family
all the
court
time.
is corrupt all the time.
Somebody in
family court is corrupt and getting screwed over at all times.
And also, now you said, like you said that, a lot of people sometimes will see the conflict between our Nevada judges and family court, and they will think that we're there as watchdogs, when really that's just a side effect of what's happening. I mean, we never created ONJ to be watchdogs. We just tried to educate. I mean, if you look at the videos, they just have the names and the statutes.
And that's something I think people need more of, is not only the exposure, because, like, again, if you expose it and you take the power out of the judge's hands, the power out of the attorney's hands, and you put it into the litigants or into the family's hands, they can make better decisions. They can be better informed. That's why I love what you do.
The channel's
you get to inform them. You know what I mean?
Yeah.
But to me, like you said, there's a law for this. There's a litigation for that. There's a statute for this. Oh, that's right. But they found the back door this way. You know what I mean? Through this law. Plain and simple, family court is simply solved very easily. The case gets filed, automatic 50-50 custody. The parent who has the best income, their own house, their own car, gets custody of the child. You have 60 days to get your evidence together and to prove that this is either the standard where the child needs to be. And on cases like that too, maybe the child goes with the mother because she can provide better. Maybe the child goes with the father. Maybe they find out they don't want the kids 6 days a week. You know what I mean? Maybe it just doesn't fit their work schedule or their new lifestyle because now they're not together no more. They're going to be dating. They're going to be doing other things. You let the family determine it in those 60 days with the evidence, with having a thing immediately. And you get people who aren't scared to go file paperwork. Like if I go file paperwork, when I did, I had to pay $8,000 in child support, TANF, all this other stuff for a child I had custody of. But the child lived with me. The mom got rent assistance, got food stamps. And then when I had to go to the hearing, like, hey, you're trying to suspend my license. They're like, well, yeah, because the mom. I'm like, the mom doesn't have custody of the kid. I do. They're like, oh, we didn't know that. We didn't check. You know what I mean? So if you had automatic 50-50s from the start and then let the litigants do their jobs and the attorneys do their jobs, you got less power in the judges, less power with the attorneys. You got less people scared to file. You know what I mean? And then you can get a lot of less contempt of court too, because less people are violating the court order that's given because it's fair. You start out fair and then you use your evidence to work your way.
The problem is that not everybody agrees to what's fair. That's why that's why the courts get involved. Of course,
that's why you got 60 days evidence.
Of course, the ideal situation is families come to their own agreement. That's what the judges want too. And the problem is that there's situations where there's just this impasse and they don't agree. And then, so what happens is they need some third party to decide it for them. And that's going to end up being the government. That's what family court has to do. Because, I mean, if you had the situation like that where I had to agree with my ex, it would have never happened. Never.
Oh, that's
why it would have never happened.
My kid.
Yeah. And so, I mean, it's just the situation is, I get what you're saying. There's a lot of frustration about the unfairness. And it's just one of those things that it's just built into an adversarial system when people are fighting each other.
That's what I'm saying. If it started out fair 50-50, you'd have a lot less adversarialness.
That's what I'm saying. The definition of fair is unclear. It's clear to the person who says it's fair, but it's not always clear to the other person.
Well, I mean, statistically, the best interest of the child would be to raise by the father anyways.
But then you're just going to have debates about that and fights about that. And I don't know if you guys know this. A lot of people don't know this, but everybody knows we have the joint physical stuff going on now. Everybody knows about how before that, moms usually got custody. Very few people know that before that, dads got custody by default. They already did that.
And how successful was it?
Apparently, it wasn't, because then they switched from that to moms getting custody all the time.
Well, that would have been around the 60s?
You know what? It's discussed in a case called Mosley v. Figliuzzi at length. The Supreme Court does an amazing job going through the summary. Please check it out if you get a chance. They call it the pendulum swinging from one side to the other.
When did that occur? Like what?
I haven't memorized it, but in that case, I'm sure they talk.
If you had to shoot 60s, 70s.
I would probably guess before industrialization, but this is a guess.
So in the 20s.
I'm guessing. I just don't know. I mean, I don't know. All I know is for sure, now we have joint. It used to be moms and it used to be dads before that. I know those three things, but I don't know the timelines.
I'm saying statistically, if we look at it, when the mothers have gotten custody or raised by a single mother, crime rate, suicide rate, teenage pregnancy, drug use, incarceration.
For all we know before,
by single mothers.
Here's something I'm going to say. Again, speculating. For all we know before, when dads were getting custody all the time, there may have been studies that showed other issues. We just don't know. This isn't a topic that I looked into. It's an interesting point. I think that the more we shift away from gender wars, the better. I think we don't want the genders fighting each other anymore. I think the genders should unite and basically focus on getting a competent family court system that knows how to do their job correctly and transparency. I don't think this is, the sooner we move away from moms versus dads, the better.
It shouldn't be like that.
Well, that's why I want the 50-50 from jump. Because there's no argument.
Which is for the most part, I think, what we have.
It should be litigants versus corrupt court.
If you look at the situation now, the issues where you still see bias are the issues where the statutes don't touch. So the joint physical custody designations are coming out now. Are you noticing that? But maybe in contempt of court situations, maybe the dads get punished more harshly than the moms. Maybe in child support, maybe the moms get more deviations in favor than the dads. So you're still seeing some gender bias in the areas where the discretionary windows are still there. But I mean, I think if they solve the issue with the custody designations, maybe over time they'll be able to solve some of the other issues and move past the gender wars.
Do you think to deem somebody vexatious litigant, do you think that's a constitutional violation? Well, and do you think it's fair because they don't apply that to attorneys that do exactly the same thing?
No, I want to talk about this. I'm glad you brought this up. So for attorneys, if an attorney is vexatious and they have that has to be a state bar thing. I mean, you wouldn't declare them, they would get suspended or something.
The judges don't like to go after attorneys, and attorneys don't like to go after judges because of this election that we have.
That's the situation of the friendships and all that stuff.
The buddy club.
So I don't think that attorneys can be, if an attorney is representing someone and they're doing something vexatious, the bar would deal with that.
Yeah, but if an attorney is no, unless the judge and even if the litigant goes and report that attorney to the state bar comes back and says, "Oh, we need the judge to file a complaint," which I think is utter bullshit. I think it's just an weird excuse just to get out of it.
I'm just trying to tell you, from my perspective, if the attorney is in an advocate role, it would be weird to declare them a vexatious litigant because they're not a litigant. If an attorney is representing themselves, that's different. If an attorney is representing themselves as a party, of course, they can.
But nobody's going to go to the state bar, is what I'm saying.
I can't go into the problems with the bar and all that stuff.
And the Judicial Discipline Commission for that.
Right.
I think the Judicial Discipline Commission is a joke.
The vexatious litigant thing, going back to that, they did deal with that in a constitutional manner in the Supreme Court. It did go up to the Supreme Court. And because of the Constitution and the right to access to the courts, they created some pretty difficult standards. The problem, I think, is pro se litigants, I don't think, will know how to appeal or file a writ petition. And so you may have situations
where my book comes out.
You may have situations where you have pro se litigants being declared vexatious and they just don't know how to fix the problem. So that's probably that you could be seeing abuses of discretion there that they just don't know how to rectify. Mm-hmm. But for the most part, the standard that the Supreme Court's put in place for vexatious litigant orders considers the Constitution, and it's a good standard, I think.
Okay. Yeah. I have a book coming out. I was trying to get it out last year, but it didn't work out. So hopefully this year, and I think it's about 60 chapters. It talks about everything we talked about and then some. Mm-hmm. And it's like a pocket attorney. And good. I hope your attorneys lose your clients, because I think a lot of litigants will do much better on their own than with these attorneys that's jamming up the system and that's friends with that judge or friends with opposing counsel or what have you. And there's a lot of that going on.
You know, that's going back to the brief that was filed, is the clubby atmosphere. You know, and now that you talk about that, I do think that that's kind of being weakened a little bit lately with some of the recent appointments. I can't remember all three. One was something Mr. Judge Gordon. Off the top of my head, there were 3 recent appointments. And they aren't, as far as I can tell, part of the club that was described in that brief. Mm-hmm. And I think that might be something that hopefully the Commission on Judicial Selection and the governor continues to do, is to continue to select and appoint attorneys like that who maybe are not part of that sort of group, because then those judges are going to get on the bench and they're not going to have those connections. And that might be, if they continue to do that, that might be one of the ways to sort of thaw that bias you're talking about with it between attorneys and judges. So, I mean, that's another good thing they can do. The solutions are complicated and myriad, but they're there. It just takes effort and, pinpointing what they are.
Frank, anything else, Ms. Falconi?
Well, just as somebody who also did pro se for most of my trials, and Steve's book is definitely going to help people to do the pro se thing. How do we take a lot of this power out of these judges and attorneys' hands to where the law says this is what it is, this is what happened in my case, this is what you will rule. There is no, yeah, they committed perjury, yeah, they lied, yeah, that's burglary, yeah, that's contempt of court, yeah, that's parental alienation, but, the mom was just really scared or something. Like, how do we get it to where these judges have these lower powers, and this is the law, this is the statute. You know what I mean? Because that's how I won my case. I found the laws, I found the statutes, the NRS codes, everything. I studied it, and I'm like, look, this is what she did. This is what happened. This is what the law states you must do.
I mean, what you're asking, I think, is mostly, you're talking about what I call the problem of discretion and too much of it. Mm-hmm. I do think judges need discretion. Not as much as they have. And I do think that they do need, of course, the power that they need to just make decisions in these cases. But if you're talking, again, sort of a little bit about policy, is finding out the areas where they have discretion that they really don't need and limiting it through language of the statute. Statutes that curtail their discretion to limit their power in particular areas where they really don't need it. But the way you presented it was overly vague, so I can't give you a specific. But I do agree with you. In my opinion, the judges should have only the discretion necessary depending on whatever issue is before them. And in family courts, sometimes they just have extraordinarily wide latitude. And that's what I was talking about with the attorney fee statute. That's an example. The attorney fee statute that they passed that says they can award, attorney fees, for the most part, almost whenever they want to, as long as the custody has been raised as an issue. I haven't memorized the code of it, but that to me is a very dangerous statute that's causing issues and it's making people angry. And there, I talked about when we first started talking, 18.010 sub 2B, which says you have to lose and there has to be, proof that they were just trying to harass and annoy. That's an example of taking a giant window of discretion and closing it down a little bit. But there are some areas where you just can't get rid of it and they just need it. So like you have the best interest factors, but you can't really tell them how to weigh those different factors. Like a judge might think this factor is more important than these two. I mean, you can't, sometimes there's necessary discretion.
So you're basically saying there's loopholes in there for the judges' biases.
If you're talking about judges abusing their discretion, so basically, I'm going to make a decision and I'm going to put in writing something that just sort of fits into the scheme, even though that's not what I really believe because I want this outcome. That I do believe happens sometimes, and I don't know that there's any way to deal with that through the codes or through appeals. I think the only way that a situation like that could really be dealt with would be public outrage. Sometimes the only way you can deal with even a legal exercise of discretion is through public outrage. The public just outright disagreeing with what the judge did because it didn't make any sense. This just goes back to the public being able to observe appropriately these cases and having more influence. I mean, at some point, the public and parents have to have more influence in family court than they do. At some point, it has to level out. And I think that that's just sort of the first step. And then if that happens and problems continue to arise, they can be dealt with later. But it's going to be so hard to tell really what the problem is until the public has more influence over a very important part of our court system, family court.
Well, Mr. Falconi, I'd like to thank you for coming out. Mark is going to zoom in on you. You have the final say, whatever you want to say. Go to your YouTube channel or what have you, and your point of contact if you want.
What I'm going to do for my final say is I'm going to say if anyone out there is struggling in family court in Clark County, please go to Karen McAlee's group, family court support group. She's been dealing with the issue of supersealing of files since Wednesday. She'll be able to provide assistance to you. It's a great group. If you know any friends who are struggling in family court, definitely go to that group. You already know about me, our Nevada Judges. If you put it into Google, you'll find it in 2 seconds. Thank you.
Yeah. Frank, thanks for coming on. Mr. Falconi, thanks for coming on. Folks, that's Alex Falconi. That's Alex Falconi, founder of Our Nevada Judges. He's doing great work out there, informing the public on what happens in the courtroom. There are two things that fears a corrupt judge. The first thing is exposure. The second thing is elections. So the 2 E's, remember that. Exposure and elections. And in 2026, every single district court seat will be up. All 58 seats will be up. You're going to start seeing these judges in 24 start coming out, start campaigning, and you're going to see a lot of them in 25 start campaigning. We want to provide enough information on what happens inside the courtroom so you could be a better voter when you go into the voting booth. This is Steve Sanchez, Frank Friends with Veterans in Politics. Until next time.